Hello, my name is Randall Borden, and thank you for watching my video. I am a family law attorney in Virginia and Maryland, and I'm happy to bring you this information. So today we're going to be talking about spousal support, also called alimony. In Virginia, spousal support is awarded according to statutory factors, which means, unlike child support, there is no fixed schedule for the court to determine spousal support. Now, that being said, the courts do have authority to award pendente lite support, which means support during the litigation, so after you file, during the litigation, but before the final trial, before the final hearing. So in other words, it would be for a temporary period for a few months while the case is going on. Now, in Virginia, that amount does have numbers connected to it, and depends upon whether or not the parties have an income that's far enough different. In other words, the payor spouse has to have a much higher income than the recipient spouse, and then it also depends on whether or not they're children. So that pendente lite spousal support, of course, that has to be requested in the complaint or as a motion filed during the divorce case, and then you'd go to court, have a hearing, put on your evidence, and then the court would award spousal support and of course child support also if they're children, and then that award or that amount would be paid until the final trial in the matter. So that's kind of the easy answer. Then as far as getting support or alimony after the trial, again, that depends on the factors that are set out in the Virginia statute, and typically the party arguing for spousal support would go down each of those factors, state whether or not they apply. If they do apply, do they apply in favor of the spouse seeking support, or would they apply in favor of the spouse who does not want to pay support? Then based on those factors, the judge would weigh each of those factors. Well, the judge must determine whether those factors apply and then announce how those factors affected the judge's decision. So spousal support can take many forms. So one form would be, which is traditional, payment for the rest of the person's life. That is kind of becoming less favored because there are other benefits like retirement plans or Social Security when the party reaches a certain age. And in fact, Virginia recently passed a law saying that for purposes of modifying spousal support, reaching retirement age by the payor is a basis for requesting a hearing to modify the support. As far as what kind of support, there's, again, permanent support for the rest of your life. There would be a limited term. What is favored by the judges, again, this is not set out in the code, is for half the length of the marriage. And this is just kind of a rough guess, rule of thumb, that you would only qualify for spousal support if you've been married for at least 10 years. Again, that's not set in writing. That's not a hard and fast rule. The amount could change once one of the parties starts receiving, say, retirement benefits. I mean, obviously, if the ex-spouse is going to be getting, payments from a pension plan or a government fund, then the payor spouse should have the obligation to go down. Maybe not go down to zero, but at least, to offset the burden on the payor spouse. So you have the amount, you have the time period, you have the ability to go back to court and modify it, and you also have what's called rehabilitative spousal support, and that would be a situation to put the spouse back to their position as if they had never met their husband. The classic example of that would be that a husband, man and a woman, are married in college. The woman drops out of college to support the husband. The husband goes on to medical school, gets a great high-paying job, and then the parties get divorced. So rehabilitative spousal support would be, say, tuition so that the ex-wife could go back and finish college and put herself, to the position that she would have been in if she hadn't met her husband. As far as the termination of spousal support, well, again, if it has a limited time period, then it ends at that time period. If either party gets remarried, if the recipient spouse gets remarried, then it would end. If the recipient spouse, ex-spouse, has a relationship that is in the nature of a marriage, and there are a few very interesting cases on that. The most important thing to remember is proving that, and that can get very expensive, like hiring a private investigator to, watch the ex-spouse's home for many, many days or weeks. And then, of course, if either party dies, then the spousal support would end. So unfortunately, or fortunately, the legislatures have made the decision that the answer is it depends, and they've left it, rather than, again, by comparison to child support, where there are statutory factors and the amount can be predicted very, very precisely. Spousal support does not have that degree of specificity. So with spousal support, you would have to go to court and have the judge decide it based on weighing the factors. That's a decision that was made by the legislature. And to leave it up to the judge, so that the judge obviously knows the case better than the legislature does, and to leave it up to the trial judge to determine what the amount would be and how long it would last, or not awarded at all. So again, that's the best answer I can give. Each situation will depend upon your facts, going through the statutory factors, trying to figure out which ones apply to you. That's really what the lawyer will be able to do for you. And then you have to go to court and prove your facts, and then have the judge convinced that those facts that you can prove should, weigh it in your favor, and then to increase the amount. Or if you're opposed to it, decrease the amount. So that's what I can tell you. My name's Randall Borden, and please subscribe to this channel. I hope to bring you many more like this. As I said, I'm a family law, and I hope to see you again. Thank you.